Hello everyone, welcome to my channel Learn Law with Professor Rashmi. We have started a series of lectures on environmental law. I hope you have already gone through those videos. Do let me know your feedback in the comment section. In earlier lectures, we have discussed Stockholm Conference and environmental protection under law of torts. Today, we are going to discuss environmental protection under law of crimes. In today's video lecture, we are going to discuss a very interesting and important case law of environmental law, and I am sure you will enjoy this video lecture thoroughly. Environmental protection under law of crimes in India. When we talk about environmental protection under law of crimes, we have to talk about IPC and CRPC. IPC is Indian Penal Code and CRPC is Criminal Procedure Code. Coming to the provisions of IPC, Chapter 14 of Indian Penal Code deals with the offences affecting public health, safety, convenience, decency and morals. So what is the object of this Chapter 14? It is to safeguard public health, safety and convenience and which causes environmental pollution and make such acts punishable. Section 268 of IPC talks about public nuisance. What is public nuisance? Public nuisance is any act or omission which causes injury to another person by polluting the environment and which can be controlled. So this is the definition of public nuisance given by section 268. In one of the leading case, K. Ramakrishnan versus State of Kerala, AIR 1999, Kerala High Court had held that smoking in public place amounts to public nuisance and cases can be filed under section 290 of Indian Penal Code. Coming to next, section 269 to 271. Before we move ahead, you can also here mention famous case of Murli Devra versus Union of India. 2001 case, if you are aware that this case is about smoking in public places, that it said that it is a fundamental right of passive smokers under Article 21 and that is the reason in public places smoking shouldn't be allowed. So you can also mention Murli Devra case versus Union of India under this topic of IPC because here 290 was invoked, right? Coming to 269 to 271. Sections 269 to 271 makes a negligent act likely to spread infection of disease dangerous to life punishable. What is the punishment? It can be 6 months of imprisonment or fine or both. Section 277 provides for fouling of water of public springs, reservoirs, wells which renders it less fit for use. Therefore, section 277 can be easily invoked or used for cases of water pollution. So what is the punishment here is 3 months of imprisonment, 500 rupees fine or both. Section 284 to 286 talks about negligent handling of poisonous substances, combustible materials, etc. Sections 426, 430, 431 and 432 covers general pollution caused by mischief and makes it punishable. So this is all about Indian Penal Code. Coming forward to CRPC. Chapter 10B and 10C of CRPC can be invoked to prevent pollution of almost all kinds. Chapter 10 Part B contains section 133 to 143 and Part C contains section 144. All these sections can provide most effective and speedy remedy for preventing and controlling public nuisance causing air, water and noise pollution. Now let us move on to section 133 of CRPC, one of the most important section of CRPC. It is essentially used to prevent public nuisance and it involves a sense of urgency, which means that magistrate, if he is not able to take the recourse immediately, then damage would be irreparable. So in order to bring this section 133 into application, what are the essential elements? First is there must be an imminent danger to property and there should be some nuisance which is going to be caused to public because of this danger. So you will have to prove that there is some imminent danger to the property and consequential nuisance to the public. Then there is a danger to life or property, suppose like collapse of building or something like that. And third and important thing is it covers existing nuisance and potential nuisance won't be covered. So it is a very specific provision. Section 33 would be a very specific provision. Here district magistrate or subdivisional magistrate or executive magistrate can invoke section 133 if he is empowered by state government to do so, when he will invoke on the report of police officer that there is some nuisance caused or on receipt of any other information about the nuisance. Now this magistrate can make a conditional order to remove public nuisance. What do you understand by conditional order here? Conditional order is basically a preliminary order where the opposite party is given sufficient opportunity to be heard, and after hearing also this opposing party is not following the order of the magistrate, this conditional order, then the order would be made absolute. So if the person is failing to follow such order, conditional order, then he can be prosecuted under section 188 of IPC and such order can be made absolute. Section 144 of public nuisance is more of a general provision, and here the order is absolute. So you will have to understand the difference between section 133 and section 144. Section 133 is of a more specific provision of public nuisance and the order is conditional. Section 144 is more general provision of public nuisance and the order is absolute. You must have come across or read about section 144 invoked during COVID times or some other times, that because of the COVID we don't want people loitering around or we don't want people roaming around, so therefore we have invoked section 144. You can go back to those news and check. So what I mean to say here is, here section 144 is more of a general provision, though order here made is absolute, but it is more of a general provision. Section 133 is specific provision which is specifically used for public nuisance cases, and there the order is initially conditional, then it can be made absolute. Now when we discuss this sections of CRPC, IPC, you must have seen that the punishment is not deterrent. The amount of fine is not deterrent. That is the reason that deterrence is not created. Though these can be used as effective remedies for environmental protection, but this drawback is always going to remain. Now there is a question, or there was a question before court of law, whether section 133 can be used against statutory bodies like municipalities, corporation, government bodies for the cases of public nuisance or not. So this was discussed further in Ratlam case. Ratlam municipality case. This was the case which I was talking about in the initial starting of the video, where I said that you are going to learn a very interesting case today. So this is a Ratlam municipality case. Ratlam municipality versus Vardichan, AIR 1980. Here section 133 public nuisance was invoked by the magistrate on the complaint received by the residents. Now let us go into or dig into the facts of the case. What are the facts of this case? Residents were suffered from the following things. The residents were suffering from following things. What were those things? Stench and stink from open drains, effluents from alcohol plants, and poor sanitation, which included open public excretion by nearby slum dwellers. So let me tell you that this case is AIR 1980, which means that Supreme Court decided this case in 1980, and this case was earlier, up till it moved to Supreme Court, it started somewhere in 1970s or 72s. It started somewhere in 1972. Now in 1972, we have already learned that Stockholm Conference happened and India was one of the member of the Stockholm Conference. And at that time, see what was happening in our country and basically in this particular Ratlam area. Now these residents are suffering from all the things. Can you imagine the state of affairs or the public what it would be facing, because there are so many things happening here. Stench and stink is coming from open drains. Then alcohol plants are letting out the effluents directly on roads, which is also not taken care by the municipality. Open drains are not closed by the municipality. Then sanitation facilities are not provided. That is the reason the slum dwellers are excreting in public open spaces. So this is the state of affairs of this particular Ratlam area at that point of time. As I told you, here residents moved to magistrate, made a complaint against municipality, and section 133 of CRPC was invoked by the magistrate. Here magistrate asked municipality to draft plan for removal of nuisance within 6 months. Now instead of working on the order given by magistrate, what this municipality is doing, it is moving an appeal to session courts, and where it got the order of magistrate reversed. What was the plea of municipality here? Municipality here is pleading financial inability. It is saying that we are not having proper finances, and that is the reason we are not able to take care of the affairs in our area. Such a lame excuse this municipality is coming with, and session courts has reversed the order. That is the reason the residents are further appealing to High Court, and High Court approved the order of the magistrate, saying that yes, municipality has to remove the nuisance within 6 months. But again, municipality is not satisfied. It is keeping on pleading its financial inability and running away from its responsibility, and that is the reason municipality is moving to Supreme Court. Now you can just imagine, from trial court to Supreme Court, it has taken 8 years, and municipality is keeping pleading this financial inability. And the reason here is the citizens or the residents of this particular area, they are suffering from this all stench, stink and everything, and apart from that they are also struggling a legal fight. Supreme Court where Justice Krishna Iyer rejected the plea of municipality, and it held that first thing, CRPC section 133 can be invoked against any statutory bodies, may it be a municipality, may it be a corporation or anything, and others regardless of cash in their coffers. So it is not relevant where they have cash in there with them or not, but they are responsible to remove the public nuisance. It is the responsibility of the municipality. Justice Krishna Iyer had taken a very stern stand here, and here you can see the Supreme Court has acted very sternly. He further commented that instead of wasting time, money and energy for this litigative zeal, see, the municipality has wasted so much of time, energy and money. So for this litigative zeal, they do have finances, but they don't have finances for clearing the nuisance, is what was his opinion. Whether it would have focused on cleaning the streets and constructing the drains by rousing the people's effort, so it could have taken or made an appeal to people that let us do Shramadan, so people's need would have met long ago. Supreme Court further directed municipality to provide drainage system within 1 year, stop effluents from alcohol plant and improve sanitary conditions. With respect to finances, he further mentioned that if municipality is not having proper finances, it can take loan from the state government or any other appropriate authority, but it is the responsibility of municipality to clear the nuisance whatever is discharged within 1 year. He also further mentioned that IPC and CRPC are of ancient vintage, isn't it? These are age-old laws, but when new social dimension or orientation would be given for imparting justice, then we can have a beautiful remedial weapon of versatile use. That is the essence of IPC and CRPC provisions. This was the most important Ratlam municipality case, in which we discussed that section 133 can be invoked against corporations, municipalities and statutory bodies. Always remember that in case of nuisance, section 133 CRPC Ratlam municipality case is of immense importance. Never ever forget this case law. Moving forward to some other cases with respect to section 133. First is Govind Singh versus Shanti Sarup, AIR 1979. What had happened here? Appellant was in the occupation of baking, had constructed an oven and a chimney which created a public nuisance. Application was filed under section 133 of CRPC, and subdivisional magistrate gave a conditional order to demolish the oven and chimney within 10 days and to show cause why order shouldn't be confirmed. On hearing, the magistrate directed the appellant to stop carrying on trade of baker at a particular site. Then the appeal went to High Court. Again, High Court held the magistrate order. Therefore, appellant had to move to Supreme Court. Supreme Court said that this is not only a right of private individual, but health and safety and convenience of public at large has to be taken care of. Supreme Court also commented here, very pertinent to note that Supreme Court here commented, magistrate order is very broad. Appellant can carry trade of baker from particular site, Only he has to demolish the oven and chimney within a month. So Supreme Court was of the opinion that yes, whatever nuisance is caused because of that oven and chimney, it has to be demolished. But the magistrate order of totally stopping the particular business or trade shall not be allowed. So he can continue his trade of baking provided he is demolishing the oven and chimney which is causing a nuisance. It has to be done within a month. This was the Supreme Court order. Here again section 133 was invoked. Next case is Krishnan Gopal versus State of Madhya Pradesh, 1986, Criminal Law Journal. Here the noise and air pollution was caused because of the glucose factory, which was few feet away from the house of the complainant. The ash from the boiler factory was also causing great deal of atmospheric pollution, and factory, because it was run round the clock, her husband, who was suffering from heart ailment, was disturbed by the booming sound of this boiler. The case was argued before the High Court, where it was contended that it is the only house and therefore cannot be considered as a case of public nuisance. Only one person is complaining, and this is not a case of public nuisance, and section 133 private nuisance is not permissible. Hence magistrate cannot invoke this section 133. Here High Court said that it is not the intention of law that large people should come forward and complain. So it is not necessary that because I want to have invoke section 133, I should have a list of people who would come forward and complain under section 133. No particular number of complainants are needed. Sub-divisional magistrate can invoke section 133 even on the receipt of single complaint by single person, but it should be a case of public nuisance. Here the ash from the boiler or continuous running which is causing the noise pollution was considered to be a public nuisance. High Court further pointed out that granting permission for installation of boiler in residential locality and running the factory itself is blatantly violative of the law. How is this factory, running of this factory is allowed, is the first point which High Court pointed out. How this is allowed in the residential area. Therefore, factory was immediately removed from the premises. It was ordered that factory should be immediately removed from the premises without any further loss of time. So here we have discussed the cases under public nuisance. Govind Singh versus Shanti Saroo, which talks about the broad order of magistrate, you can say, and Krishnan Gopal was a state of MP, which talks about no particular number of people are required to prove it to be a public nuisance. A single person can also file a complaint with the magistrate and it can be treated as a case of public nuisance. This was all about IPC and CRPC, that is environmental protection under law of crimes. I hope you have liked this video lecture. Do let me know your opinions and feedback in the comment box. We would soon meet with the next lecture. Till then, keep studying. Thank you and bye.